Today, we will be exploring part 2 of the interesting case of the problematic poodle. It will continue with the story we started last time, detailing the incidents and legal disputes surrounding Charlie, the standard poodle, and his owners Ian and Marguerite Suzette. Last time, in part 1, we went over how, after a trial in 2021 in the Provincial Court of British Columbia, Mr. Ian Suzette was convicted of an offense against the Responsible Dog Ownership Bylaw of the Regional District of Central Okanagan and fined $1,000. To be precise, he was convicted of causing or permitting Charlie to become a dangerous dog, contrary to Section 36 of the bylaw. And this conviction was due to an incident which occurred on January 29th, 2020. In that incident, Mr. Suzette had been exercising Charlie off-leash on the field of a college campus in Kelowna, British Columbia, when Charlie had bitten and caused serious injuries to a smaller dog named Spike, owned by a Miss Melanie Michaels. Unsatisfied with the outcome of the trial, Mr. Suzette had decided to appeal his conviction. The appeal was filed and in the spring of 2022 heard before Justice G.P. Wetherill of the Supreme Court of British Columbia. For the appeal, Mr. Suzette enumerated multiple grounds on which he believed his conviction should be overturned. As he had during the original trial, Mr. Suzette alleged that the Regional District of Central Okanagan and its animal control officer and prosecutor were biased against him. In addition to that, he also alleged that Miss Michaels and the Judicial Justice of the Peace, or JJP for short, who had presided over his original trial, were also biased. Mr. Suzette asserted that during his trial in the provincial court, the JJP had admitted evidence that should have been inadmissible, had not allowed him to cross-examine witnesses or to produce evidence to rebut witness evidence. He further argued that he had not been given enough time to prepare for his trial, and when he had requested an adjournment, the JJP had denied his request. All these arguments as to the unfairness of the trial or bias against Mr. Suzette were rejected by the Justice Wetherill when hearing the appeal. However, that was not the end of the matter, for there were additional grounds for appeal put forward by Mr. Suzette. Mr. Suzette suggested that the animal control bylaw was unfair in that it allowed for a dog to be deemed a dangerous dog for only one incident of aggressive behavior, i.e., one bite. He further argued that allowing an animal control officer to decide to declare a dog to be dangerous after only hearing from a couple of witnesses was authoritarian and overreaching. However, in response, Justice Wetherill dismissed these arguments, saying it was not up to the court to rewrite the bylaw to address these things that Mr. Suzette took issue with. Justice Wetherill then went over the key rulings of the Judicial Justice of the Peace from the trial to determine whether they stood up to scrutiny. To begin with, Justice Wetherill looked at the decision which had been reached by the animal control officer, and then afterwards by the provincial court, that Charlie the Poodle was a dangerous dog. He examined the definitions for the term dangerous dog found in the bylaw and in the regional and in the provincial statute known as the Community Charter. He concluded that based on these laws, it was proper for both the animal control officer and the JJP to have determined Charlie to be a dangerous dog. Both the bylaw and the community charters have similar criteria for deciding whether a dog can be classified as dangerous, including whether it has caused serious injury to another animal. In the case of Charlie, Justice Wetherill confirmed that he had certainly done so. Charlie had picked up Spike in his jaws and shaken him violently, breaking Spike's jaw and molar, and leading to the need for 2 surgeries and veterinary treatment costing over $6,000. Even after this surgery and treatment, Spike had been left with a permanently twisted jaw, meaning he could now only eat soft food. As the JJP presiding over the trial had done, Justice Wetherill was satisfied that Charlie was responsible for these injuries. This was despite Mr. Suzette's attempts at trial to argue that something or someone else may have caused these injuries. For example, perhaps they had been caused by Miss Michaels herself, since she had been kicking during the incident, in an attempt to fend off Charlie and get him to release her dog. Having ruled that the finding of Charlie to be a dangerous dog was justified, Justice Wetherill then went on to look over whether the JJP at the trial had been right to find that Mr. Suzette had, quote, caused or permitted, unquote, Charlie to become dangerous. This was the foundation of the conviction because the charge had been that Mr. Suzette had violated Section 36 of the bylaw, which read, quote, "No person shall cause or permit his or her dog to become a dangerous dog," unquote. Here at trial, the JJP had ruled that Mr. Suzette had been responsible for Charlie becoming dangerous because he had failed to exercise due diligence to prevent this. He had pointed out that at the time of the incident, he had been letting Charlie run off leash, even though this had been prohibited by the animal control bylaw. The JJP had expressed his belief that if Charlie had been on leash as the law had required, this whole unfortunate affair would never have occurred. Justice Wetherill opined that although the JJP may be right that keeping Charlie on leash as he was supposed to would have avoided the injuries to Spike, this was not what Mr. Suzette had been actually charged with. He had not been charged with allowing his dog off leash, but rather with causing or permitting the dog to become dangerous. In order for someone to cause or permit their dog to do something or become something, Justice Wetherill ruled that there needed to be evidence that the person had either actively participated in causing the thing or, at the very least, had knowledge of the thing being possible and didn't prevent it. Since there was no evidence that Mr. Suzette had actively encouraged his dog to be aggressive, and no evidence he knew the dog had aggressive tendencies, there was no proof he had caused or permitted the dangerous behavior. Consequently, on May 19th, 2022, Justice Wetherill ruled that Mr. Suzette's conviction must be overturned and his $1,000 fine nullified. And there ends part two of this case, but it's not quite the end of the story, because there would be another incident and another legal case involving Charlie and his family. If you would like to hear this third and final tale, I invite you to come back for part three of the case of the problematic poodle. And in closing, thank you for watching and listening, and I hope you found this case interesting. If you did, please consider hitting the like button and subscribing. Until next time.